Bonjour et bienvenue à tous à cette conférence de presse. Je suis Boris Proulx, reporter au journal Le Devoir et je serai le modérateur de cette conférence de presse. Hi everyone, I am Boris Proulx. I am a journalist for the newspaper Le Devoir and I'll be moderating this press conference. Just before we go to the press conference, I have a little announcement to make that we now do in the National Press Theatre. It's very important at all time to avoid the audio feedback incident. So we have to prevent disruptive and potentially harmful audio feedback incidents that can cause injuries. So if you're in-person participant, I'll ask you to keep your earpiece away from all microphones at all time, please. This is very important so we can protect the health and safety of all participants, including the interpreters, and conduct our business without interruption. Je vais le répéter en français très rapidement. On doit prévenir les incidents acoustiques perturbateurs et potentiellement dangereux susceptibles de causer des blessures. Et je vous rappelle à tous de garder votre oreillette éloignée de tous les microphones à tout moment si vous êtes dans la pièce. Et d'avoir des microphones approuvés par la tribune si vous êtes en ligne. C'est très important pour protéger la santé et la sécurité de tous les participants et de nos interprètes pour que nous puissions exercer nos activités sans interruption. Donc, merci à tous pour votre collaboration. Now to the press conference. We have today Senator Marilou McPhedran, and she's joined today by a few other participants. So I will let you introduce yourself if you don't mind. But since there's quite many of you today, I'll kindly ask you to keep your introduction remarks short so we can go ahead after that and proceed to the question and answer period that I will moderate. So on that, Senator, you have the floor.
Thank you very much, and thank you for the opportunity for us to be here to speak with members of the media. I want to welcome Zelda Perkins, who's arrived here from England to be with us, and we will speak in the following order. I will begin. My name is Marilou McPhedran, and beside me, Senator Kim Pate will speak next, then Zelda, and we will hear from Mr. Garth Caron and Ms. Kim Shore, and Dr. Julie Macfarlane will wrap up. And so I will begin by acknowledging that the Parliament of Canada is situated on the unceded, unsurrendered territory of the Algonquin and Anishinaabe peoples, and we thank them for the opportunity to be here on this land today. My bill is S-261, and it's entitled the Can't Buy Silence Act. Tabled on May 9th last year, it will change two federal laws, the Parliament of Canada Act and the Financial Administration Act, in order to stop the use of non-disclosure agreements, or NDAs, to cover up wrongdoing caused by harassment, discrimination, or violence by any entity funded by federal and therefore public funds. This bill stops the money. And that means that it will make it impossible to use federal monies for such NDAs on a go-forward basis. The bill will galvanize changes in Parliament, House of Commons, and the Senate, the Library of Parliament, the Parliamentary Protective Services, as well as all other federally funded entities, including government departments such as the Department of Justice, Crown corporations such as the CBC, departmental corporations such as federally funded granting agencies, and non-governmental organizations that receive federal funding, such as Hockey Canada or Gymnastics Canada. The bill builds on Bill C-65 that in 2021 brought in anti-harassment measures but allows NDAs that can reinforce secret, unaccountable corporate cultures that protect predators. That's not how NDAs started. They're contractual agreements originally created to protect trade secrets and proprietary information, not harassment and violence. Now they're used as a matter of default in a wide range of civil settlement agreements, such as the Hockey Canada agreements. The misuse of NDAs includes using them as a gag tool, often in exchange for money. As a result, NDAs can enable secret settlements that hide wrongdoing, sometimes criminal acts, by buying the silence of a victim or whistleblower. thereby shielding perpetrators and institutions from accountability and creating environments that enable harassment and discrimination or violence to continue. The term in my bill, federally funded entities, is there because not only Parliament and federal government departments are covered by this bill, it includes federally funded corporations and agencies, NGOs receiving funding to operate. The damage that's done to people who in the past have signed NDAs and continue to be silenced and stressed by the threat of litigation against them. Currently, for example, there are CBC cases ongoing, which they fear they can't afford, knowing the other side can use federal funds to threaten or to follow through on the threat. The Can't Buy Silence Bill is not an absolute ban on all NDAs. It respects the choice of adults who have brought complaints about harassment and discrimination or violence in a federally funded context to decide for themselves if they want a settlement that includes an NDA, but always with non-negotiable protections as to NDAs as contracts and limits on what a person can give up. The bill puts in place two restrictions, one on NDAs going forward and the other covering all NDAs, regardless of when they were made. Before any settlement can be completed, the complainant must indicate their preference for an NDA in writing and only after receiving independent legal advice that includes outlining options other than an NDA to protect their confidentiality. There's precise wording in the bill, which I won't go into right now. The limits on what a person who wants an NDA can give up are stipulated in the bill, and if an NDA is signed, ever, complainants cannot be silenced by the NDA because the bill amends the Financial Administration Act to ensure they can speak freely and protects permitted disclosures in several clauses of the bill. That includes counselors, that includes members of the family. The jurisdiction, it can only cover federal jurisdiction, so there are limits, partly because of Canada's constitutionally defined divisions of power. The bill builds on the authority of Treasury Board and reporting requirements already in place, using existing federal laws to make federally funded entities more transparent and accountable. It adds new mandatory public reporting requirements to the President of Treasury Board, who in turn is required to report through the Parliament of Canada Act and the Financial Administration Act. This will prevent federally funded entities from using public monies to pay for settlements in relation to harassment and violence or discrimination if the settlement is to include a non-disclosure agreement. And it prevents those entities from using public monies to enforce NDAs, past, present, and future, and thereby silence complainants in cases of discrimination, harassment, or violence. I won't go into more detail at this point because our time is indeed very limited. I do want to note, though, that in a meeting that I had with Minister Anand, the President of Treasury Board, it was possible to outline the relatively simple changes that could be made that would allow this whole new regime to come into place that would start to change the cultures that are being allowed to thrive in many federally funded entities at this time. And with no further ado, may I introduce Senator Kim Pate.
Great. Thank you very much, Senator McPhedran. And thank you. I live here on the shores of the Kitchissippi, the unceded, unsurrendered territory of the Algonquin Anishinaabe. And my introduction to the whole area of non-disclosure agreements came when I was working with women who were experiencing, or especially those who had experienced historical violence. And it was usually after they had been belittled, dealt with in ways that were incredibly problematic. The shame and stigma that attaches and that is part of the victim-blaming culture that many of them had experienced had contributed to them being re-abused, re-victimized by the criminal legal system. And often, despite incontrovertible evidence of abuse, many perpetrators, once they knew that that evidence was available and that would be brought forward, particularly if they were in a much more privileged position, would often not want that made public for fairly obvious reasons, and therefore would offer cash to sometimes near bankrupt, impoverished women who had been struggling. And they would offer that in exchange for their silence, and that's where we first became aware of the non-disclosure agreements. They essentially allow perpetrators to re-victimize others and deny culpability. Then, as I started working with those who are in the criminal legal system, particularly those in prison, it became very clear that this protection of perpetrators of injustice and wrongdoing and the shroud of secrecy extended within our institutions as well. And virtually every prisoner who has brought forward a complaint that would be considered, often a criminal charge, could give rise to a criminal charge, often is met with an offer of a cash settlement, usually in a context where they are struggling again to even figure out how to manage if they've been released from prison, how to live, how to work, how to actually be in the community. And so it's very easy for perpetrators to then, including systems like the Correctional Service of Canada, to negotiate non-disclosure agreements in exchange for cash settlements. And so, part of the reason that I think this is vitally important, of course, those, as Senator McPhedran has said, those individuals who want to have a non-disclosure agreement for their own reasons, but not because it's the only way to have some kind of closure. Of course they should be entitled to that, but that's not most of the people that I have had the responsibility of walking with. And so when we know that the primary reason that most people engage in this is that they have no idea and often feel very alone in terms of their fight for justice in an incredibly unjust process. The bottom line is we have not taken yet, in my humble opinion, violence against women and girls seriously in this country, as well as those who experience gender-based violence generally. And until we do that, this kind of issue will continue. And so this is yet another step in the move towards trying to ensure that we make our systems, make our country, and individuals more accountable. Thank you.
Thank you, Senator Pate. And may I ask, welcome Zelda Perkins from England to Canada, and ask you to make some brief remarks, please.
Thank you. Well, first of all, I'd like to say thank you very much.
Go ahead.
Thank you very much for welcoming me here. And I wanted to thank both Senator McPhedran and Senator Pate for the amazing work that you're doing, particularly Senator McPhedran, the bill that you're introducing. I think they've both explained very clearly the issues which are becoming more and more understood globally. But ultimately, this is about the abuse of power. It's about the abuse of power and the integrity of law. And to have a legally enforceable agreement that hides harm to anybody is an unarguable situation to me. I have to say I'm pretty shocked that the federal government of Canada is prepared to use agreements similar to the sort of agreement that I was made to sign with Harvey Weinstein over 30 years ago. And I hate to put them both in the same sentence, but essentially that is the position that the government is taking if they are prepared to buy silence of victims of abuse. The first line of defense for abusers is silence and secrecy. And this is something that needs to be removed, and it particularly needs to be removed from a federal institution that is using public money. So I would like to really encourage the government to take this very seriously. PEI has led the way, which is unbelievably impressive. It's actually leading the way globally in terms of its legislation against the misuse of NDAs. And I think that Canada runs the risk of falling behind if they don't step forward. And this bill is the first step on that journey. And I think it sends a really clear message globally and means that they are coming in line with America, the UK, and Ireland, which are all moving forward very actively in this area.
Thank you very much, Zelda. And Dr. Julie Macfarlane, please.
Thank you, Senator McPhedran. I was a law professor for 40 years until I discovered my university was using an NDA to secretly pass a known sexual predator, a faculty member, to another law school. And I resigned in disgust after not being able to talk them out of doing that. But somewhat similarly to Senator Pate, my first encounter with NDAs was when I sued the Anglican Church for historic sexual abuse. And I was told they would expect an NDA. And my response was, well, I'm not signing it. And they never raised it again. And part of my settlement was an agreement that they would not use them in future. So one of the things that's very important to me as the co-founder with Zelda of Can't Buy My Silence, because of my background, is to replace so many of the myths and misinformation that's out there that has reinforced the use of NDAs over the years. There is quite a lot of information in the press package. We can answer more questions, but just a few highlights. 1 in 3 people will sign an NDA during the course of their working life. And believe me, if you're stocking the shelves at Walmart and you just complained about sexual harassment, your NDA is not about keeping trade secrets. 4 times as many women as men will sign NDAs, and disproportionate numbers of people of color will sign NDAs relative to white people. We now know from our own data that we have produced with Speak Up Revolution in the UK that 1/3 of people who have experienced discrimination and harassment in the workplace will not make a complaint at all because they anticipate they're going to be asked to sign an NDA and they don't want to sign one. And the last thing I'll just touch on is that we hear a lot about, as a lawyer, I hear a lot from other lawyers about how the sky will fall if we have no NDAs and there will be no settlement ever again, which I always suspected was not true. But I went and looked at the figures in the US, where there has been legislation for much longer. I took the first 9 states that legislated from 2017 to 2020, so they've had a little time for this to work through the system. And I looked at the sexual harassment cases as a sample. The settlement rate went up by 9%. It didn't go down at all, which to us, because we speak to hundreds of people in this situation, is not surprising, because people are starting to say, I will not sign, and therefore I will not settle. So I want to now move on to introduce just 2 people out of those hundreds whose stories I think will make a difference to you, because this is their real life lived experience. We hear very regularly from people who either work for the federal government. There was, in fact, someone who was in our original press conference when Senator McPhedran introduced the bill, Robin Brown. And we also hear from people at federally funded agencies. Let me just say we hear a lot from people who have worked at the CBC. And we also hear from people in sports, Hockey Canada, and other areas. But the 2 people we're going to introduce to you this morning to speak are, first of all, Garth Caron, who was a former RCMP officer, who's going to speak about his experience of an NDA, and secondly, Kim Shaw, who has been a tireless advocate for safe sports and was the co-founder of Gymnasts for Change. And I believe that Garth is going to speak first.
Thank you all for your introductions, and I appreciate the fact that I certainly learned some more information from them. Just to set the record straight, I was not an RCMP officer. I was a public service employee in detachments and in a national unit. NDAs were originally used to protect trade secrets. They were used in the 1940s, starting in merchant marine law. Then they started to develop their own little way of including covering up sexual assaults, harassment, and discrimination. And it was mentioned in the previous speeches that it was to protect trade secrets. I'm not a trade secret. The RCMP, I had 2 harassment files with them. The first agreement was called a Memorandum of Agreement. Now, whether that's an NDA, I don't know. I was never brought into the picture about NDAs. They never mentioned NDAs. And then when the agreements were signed, the union signed them off. So both the employer and the union are implicant in this type of behavior. It's the expectation of a federal government employee when you're working for the federal government and the Treasury Board and the Public Service Commission, they should know and understand what these things do, but they don't. My two harassment files are, in my quote, are my chattel of silence, and it remains today, and it will remain after I leave this planet. That's why we have to change the legislation, and it has to be brought in. My agreements didn't include the following: trade secrets, proprietary information, or intellectual property. They weren't in the NDAs. So it's kind of difficult to put into words what this is all about, because I've carried this daily interaction between myself and everything out there for the past 10 years after I was forced to retire after the last MDA, or the last agreement. They put me in a position where I would have to retire, which was fine. I'm going on 74-year-old now, and I shouldn't have to worry about this at my age as a retired person. The results overall with my department, the RCMP, over the past 10 or 12 years have been a women's class action, a class action for the male employees, a class action for Indigenous persons under arrest, and another class action coming up in the future on racism within the RCMP. So that's cost the Canadian taxpayers a lot of money over the past 10 years. And these issues show how bad it is. And I certainly would like to know how many NDAs are out there that the federal government has signed off, but that information is very, very difficult to find. And Hockey Canada is a perfect example of what set all of this going. But I'm sure that further input into it would show that other government departments have just as many NDAs as that situation occurred. So Bill S-261 is going to change the playing field.
I'm sorry, but I need to allow time for Kim as well, please. Thank you very
I
much.
just want to add,
Thank
I
you.
have read both of Garth's memoranda of understanding, and both include NDAs and non-disparagement clauses very clearly.
Thank you. That's a helpful clarification. Thank you again, Garth. And then if I may ask Kim Chor to join us now, please. And thank you both for your advocacy and your willingness to be here today.
I just want to offer my thanks to you, Senator McPhedran, and Dr. Julie Macfarlane, and the many other people who have brought the Can't Buy Silence Act to life, because the use of non-disclosure agreements persists in our Canadian sports system despite going against the very foundation of safe sport. NDAs in sport are very sneaky. They are often disguised in various forms like mandatory athlete contracts, confidentiality clauses that are embedded right into the disciplinary processes, governance policies and practice that protect the reputation of the organization above athlete well-being, and even towards whistleblowers and staff who are fired for challenging wrongdoing, but forced to sign an NDA in exchange for their rightful severance pay. And contrary to popular belief, athletes are not the power holders in sport. Our athletes are really at the mercy of funding organizations, coaches, administrators, and the many other stakeholders who've quite literally built their careers off the backs of children and athletes. Sport has actually been allowed to police itself for at least 50 years, including the use of NDAs, with leaders basically being granted unchecked power with zero accountability to the athletes they're supposed to be protecting. And most of these athletes are children. Silence is easily bought from these athletes, their parents, and other whistleblowers who know too much and threaten to disrupt the status quo, because retaliation comes in endless forms. Silencing mechanisms like NDAs are really powerful weapons that just prevent truth from being revealed. The reality is abuse, corruption, and human rights violations have gone unaccounted for at all levels of sport, and the NDAs are protecting the powerful and the privileged, not the vulnerable. So 2 years ago, since athletes and survivors started bringing their lived experience to the forefront, then Minister Pascal Saint-Onge said the silence in sport needs to be broken. But since then, only Band-Aid fixes have been applied. There is no plan for a national inquiry with judicial power into what 3 sport ministers have admitted is an absolute crisis in sport. We're left to speculate that the government is doing nothing or just doesn't care. Eliminating the use of NDAs means one less tool in the perpetrator's toolkit. So while we wait in sport for government to take meaningful action, the Can't Buy Silence Act will play a very important role in limiting secrecy and cover-ups enabled by NDAs and will shine a light on the dark corners of our rotting sports system. Thank you.
And we are now open for questions.
Merci, thank you. And now we'll proceed to the question period. I noticed there are reporters on Zoom, so if you're attending on Zoom, please use the raise hand function at this point, and then I'll hand you over the mic. But first off, in the room, Ashley Burke, CBC.
Thanks for taking our questions. Ms. Perkins, if you're comfortable talking about it, Harvey Weinstein is back in court today. It's the first time since after his conviction was overturned. If you're comfortable talking about it, what's your reaction to that conviction being overturned, and what impact has this verdict had on you?
Well, obviously it's a tragedy, and this is about a law point. It's not about the guilt of a perpetrator. I don't think this is the correct place to speak about it because I'm here, I don't want to distract from the essence of what we're talking about today, which is federal workers in Canada who are being abused by a similar tool, which is NDAs, and the fact that, we have a government here that are using that tool. So I think, this isn't the correct environment to talk about it, but it is obviously a legal tragedy.
What's your message about your experience and what you've gone through, and in this case, that you want to share with Canadian lawmakers, and what do you want them to do?
Well, I think as both Tarana Burke and Anita Hill have said in the last few days, it is the power of communities and the power of movements that really call into account governments and make change happen. And that's why movements like Can't Buy My Silence and senators that support us are so important.
Thank you. Merci. I see no hand on Zoom. So if you're attending on Zoom, please use the raise hand function at this moment if you want to be recognized. Otherwise, Ashley, do you have an extra follow-up?
Senator McPhedran, can you talk about where your bill is at and what challenges, if you are facing challenges, are happening right now?
Yes, I'd be happy to, and I thank you for the question. The bill is in the Senate. It has not proceeded very far in the chamber, largely because the Senate has its own policy that has allowance for NDAs, and because many senators are really not very aware of the issues. So what I've been spending time doing, in addition to working with civil society advocates, is having discussions one-on-one with senators to help them appreciate our situation as an institution and what the bill would actually do. And that's a fairly lengthy process, but it needs to happen before we get to the stage where we're asking senators to make a decision on the bill. I'll just give you a specific example. Senator Pate is here today because of a conversation that we had where she said, I didn't know that NDAs were being used in prisons. We were actually on our way to a prison when we started talking about this. And she said, oh. And so those are the kinds of conversations that I'm in the midst of having. I will be speaking to the bill as we get closer to the adjournment for the summer.
What are you hoping today sharing these stories means for your bill?
Sorry, Ashley.
What are you hoping that this press conference means for your bill?
Well, I would love the Government of Canada to take some action on this. I think it's incontrovertible that silence protects predators. And although there are challenges in terms of the federal provincial jurisdiction, the truth of the matter is there's nothing stopping a federal government from addressing what's happening in federal work environments. So a meeting like today, the meetings that we're having throughout the day, the fact that there are going to be conversations with specific parliamentarians, all of this is part of a process where the bill is there. And I certainly would welcome the Government of Canada stealing that bill and taking the initiative. It's not the first time that that's happened with private members' bills. And I think that the seeming lack of interest, serious interest in doing something is of great concern, but we can't just accept being ignored. We have to continue to have these conversations. We have to continue to raise awareness. I don't think our problem is public awareness. I think our problem is here on the Hill, and that's where we're focusing.
Oh, go ahead.
And Ms. Perkins, can you talk more about your personal experience with an NDA, what it meant for you?
Well, it stole 25 years of my life. And I thought that was an unusual experience. And since Dr. Macfarlane and I started Can't Buy My Silence, and since I broke my NDA in 2017, I have become aware of the enormous harm and the endemic nature of NDAs. They cross all sectors, all stratas of society, and the amount of damage that they have caused and are still causing every day are unconscionable. I essentially lost my career at 24 because I chose to speak up and do something that I presumed was normal and right, which was to report a sexual predator. And the majority of people who speak up and are silenced are only trying to speak up about wrongdoing. And if we live in a society where those who choose to do the right thing are penalised and continually abused by having a basic human right taken away from them, which is owning their voice, owning their trauma, being able to find help, being able to discuss things with their family, with the police, with a therapist, then we are in really big trouble.
And that happened in your case? You said
yes, that's what happened in my case.
Is there anything else you're comfortable sharing about that?
As I said, I don't think it's particularly helpful to this conversation, apart from acknowledging that the experience of people who've signed NDAs is far more stratospheric and damaging than I think most people understand. And that's why it's so important that the secrecy veil is removed. And I think as public awareness and legislation around the globe is changing, it's really important that Canada stays in step with that, because no government wants to be found to be lacking in this area. People only go to the press when the abuse is continued, and that abuse is continued by being silenced by an NDA. If you deal with the problem at root, these issues are dealt with, and you have healthier environments to work in and a better government.
Actually, can I just add something to this, which is that we realize that there is a perception out there that these are occasionally problems, and only in particular areas. Sexual harassment is what NDAs are always associated with. First of all, we have found enormous amounts of use of NDAs in relation to discrimination complaints. That might be racial discrimination, disability discrimination, LGBTQ, whatever it might be. Lots and lots of use in discrimination cases. And secondly, I decided to look at all the cases in Ontario in a given year, sexual harassment cases only, in order, using some existing research data, to work out just how many NDAs were being signed just in Ontario, just in a single year, just for sexual harassment. And the figure that came up was tens of thousands, 300 a week. So I think that makes it clear that there is so much widespread use of this, but the reason we don't know it is because these are secret settlements.
Senator Pate. Yeah, let me give you an example. Just last night I received a message through social media, a messenger, from an Indigenous woman who was told she was being let go. She indicated she was going to bring a human rights complaint about that, was offered then an NDA in exchange for a severance package, but with an agreement that she could not file a human rights complaint, she could not pursue any kind of damages, and she said her boss knew that she was in debt and needed this job. And so she feels over a barrel, and we're trying to get her legal assistance at this point to ensure that she's not left in that position where someone with the privilege, power, and state-sanctioned authority can exert that kind of pressure to silence her.
I'd just like to add one last comment because I know we've run out of time, and that is to say that we very much appreciate the fact that Minister Virani is going to make some time today, and we also appreciate the responsiveness to some degree from some ministers. I did have a meeting with Minister Anand, which I appreciate. I think now, though, what we're looking for is action, and that isn't something we've seen yet.
Zoom, I'll just use my privilege as a moderator to ask a very short question to the senators. And Boris Prou from Le Devoir, apologies if this may sound naive, but who are you up against? In other words, who goes to the defense of NDAs?
We probably have slightly different answers, but I would say in terms of the federal context, where we are today in Parliament, what we're up against is institutions that have patriarchy deep in their NDA and long history of protecting privilege, the whole notion of privilege. And what we're challenging is that privilege cannot contain the privilege to abuse and the privilege to harass. And that may seem like a no-brainer, but in fact, there's so many ways in which privilege is protected and people who challenge it are silenced that for me as a senator, working in a very secretive place myself, and knowing that there's really no way in our institution to find out what's actually going on because it all got moved away from senators and put in a secret committee. And so that's just one small example, and that's not the primary purpose of this act. We know that we have a very complex, wide-ranging environment, work environments, that are federally funded in some way, and that this is the connecting tie that we need to appreciate the degree of damage that is being done and how it's being protected and perpetuated.
Mm-hmm. And an example, as Senator McPhedran said, when I told her about how NDAs are being used in corrections, you've already heard about how they're also used in policing. Now, these are the very people we expect to not only uphold the law, but demonstrate the types of behavior we expect to be modeled for our citizenry. So you can imagine even more so when folks who are dealing with the RCMP, dealing with the Correctional Service of Canada, bring forth their allegations. They are not the holder of the record. They don't control it. So very difficult to even mount those cases. So these are, in my experience, uncontrovertible cases of not just abuses of power and privilege, but breaches of the criminal law and certainly breaches of charter and human rights. And yet they get covered over, and people are encouraged. These are folks who don't already lack credibility in many people's minds, because if they've already been criminalized and imprisoned, they're not seen as credible. If they've also had the past trauma of abuse, particularly when we're talking about some of the Indigenous women, they're not seen as credible. And so the offer of resources when corrections or the policing authorities realize they have incontrovertible proof to silence them, I think should be a concern for all of us, because it actually sets, in addition to all of these other examples, it sets a really horrendous example of how we're unable to correct behavior if we can't, and unwilling to correct behavior if we don't even ever learn about it. And you may remember about a decade ago, the government tried to stop prisoners from being able to bring civil lawsuits. Well, and they actually went behind some NDAs and brought out some trivial points to try and argue. So here they were actually trying to get the government to be able to be both silence those who have been victimized and then prevent them from ever having a remedy. And, fortunately that didn't happen, but, we know that, who knows what could happen in the future.
On that, I thank you very much, all of you, for this press conference. That puts an end to today's press conference, of course. Merci beaucoup. Merci à tous et excellente journée.
Merci.